Good morning. I'd like to thank the organizers for the opportunity to present this work. I will be talking about corporate law in the Global South. I'm a corporate law professor, so maybe it's natural that I will be talking about corporate law. Maybe not in this conference, maybe many lawyers don't actually talk about law, but I will. I'm from Brazil, and I will be talking about the Global South. That might be natural, but it's actually not. Actually, people from the Global South, they like to talk about their own countries, and they like to talk about the Global North. They haven't historically taken much interest in the Global South. So corporate law in the Global South has been generally understudied, and that is true for other areas of comparative law as well. To the extent that those laws have been studied, they have often been studied based on lenses from the Global North. So you go around the world and perhaps code Global South jurisdictions based on legal families. So Brazil is a French civil law country, China is a German civil law country, South Africa and India are common law countries. So you don't think about those countries as Global South jurisdictions, and very often you code their approaches to a variety of issues that are interest in the moment at the Global North. I would say that the general view is that corporate laws in the Global South have many problems. They might be antiquated. They might be failed transplants of Global North institutions that did not adapt to different conditions. Or they might be perfectly adequate on the books, but be plagued by enforcement challenges. Do I think this is fake news? All wrong. No, I don't. Let's be very clear about it. In my internal debates in Brazil, I'm very much a critic of enforcement problems as it pertains to Brazilian corporate law. It is also the case that China has received growing attention, and people in the audience have described it as the world's most stakeholder-oriented system of corporate governance. What I want to do here today is to present a different picture of corporate law in the Global South beyond China. In particular, I want to suggest that Global South jurisdictions have been pioneers in what I've called heterodox stakeholderism. And by heterodox stakeholderism, I mean two things. By heterodoxy, I mean different from prevailing approaches in the Global North. And second, different in a particular way, that is by incorporating broader public policy or distributional objectives. Curtis and I might call it policy channeling. So what I'll do today is present varieties of heterodox stakeholderism in the Global South. So we'll talk about the erosion of limited liability, mandatory CSR spending, mandatory CSR committees, workers' governance rights in corporate governance, racial and ethnic diversity in corporate governance, and also stakeholder-oriented provisions in constitutions of Global South jurisdictions. So those are very diverse strategies. And let me begin by talking about the erosion of limited liability. Limited liability is a quintessential characteristic of the corporate form and has been greatly eroded in my home country, Brazil, precisely in areas in which that erosion works for the benefit of stakeholders, and that would be labor law, consumer protection law, environmental law, and financial regulation. And I tried so hard because I've presented before, and my slides were messed up, and I'm like, oh, apologies, Global South slides. And I tried again, and they're messed up again. I'm so sorry about that. It's not a joke. I mean, some people have seen me present. Not a joke. I tried hard. Actually, Matt Mark Rowe is like, Mariana, are you reviewing your slides? And I'm like, no, I'm a relaxed person. But now I realize I should have reviewed my slides. Apologies for that. But look, this is the provision that you have in Brazil's environmental statute. Veil piercing may apply whenever legal personality is an impediment to compensation of harms to the environment. So whenever liability might help you, it's not available in Brazil. So this is very broad and applies in other areas as well. But actually, Brazil is not alone. There have been also other forms of erosion of limited liability in other Global South jurisdictions, including in India, when enterprise liability emerged in response to a major environmental disaster caused by a multinational, as well as in Colombia, there's a famous constitutional case in which the Supreme Court mitigated limited liability in a case involving workers' pensions. Another manifestation of heterodox stakeholderism is mandatory CSR spending. India is very famous for having adopted a requirement of a mandatory 2% spending on CSR. Actually, initially it was adopted on a comply or explain basis. Later it became mandatory. It's interesting that it was advanced as responding to a need for a perception correction in view of the big division in the country and the growing divide between the rich and the poor. But it is also not alone. Other global south jurisdictions have different experiments in mandatory CSR spending, including Mauritius, Nepal, and Indonesia. We were just talking about growing committees, CSR, ESG committees in the US as a result of private ordering or market practice, but those have been mandated by law in global south jurisdictions. South Africa did it in 2008. India did it in connection with this mandatory CSR spending rule in 2013. There are also modalities of stakeholder empowerment in corporate governance in the global south. We also have it in the global north. One of the most famous differences in comparative corporate governance is the existence of worker participation in corporate boards in Germany, for instance. It's really interesting in this respect. I've quoted the largest global north, the constitutions in the largest global north economies and in the largest global south economies, and whether they talk about worker co-determination. And the global south constitutions are more likely to talk about co-determination, but less likely to have co-determination. So co-determination or worker participation on boards is more prevalent in the global north compared to the global south. But South Africa has had interesting initiatives in terms of other forms of worker governance rights. So workers are able to enforce the Companies Act by filing derivative suits, by filing director disqualification suits, by filing for bankruptcy and voting on and opining on bankruptcy plans. Another modality of heterodox stakeholderism concerns the issue of diversity in corporate governance. Usually the story goes that diversity in corporate governance became an issue or a theme when Norway had its landmark statute providing for quotas for women on corporate boards. And now, only now, in recent years, the issue of racial diversity has emerged in the US in particular. But there have been interesting measures based on the so-called de-racialization of corporate governance in the global south. When Nelson Mandela was just out of prison in 1990, he gave a speech when he decried that less than 10 conglomerates control almost 90% of the Johannesburg Stock Exchange, and boards were all white and male. So this became a central issue for South Africa, which he saw as imperative to the goal of ending white domination into all forms and de-racializing the exercise of economic power. There have been several initiatives on that front. In the 1990s, there was the Black Economic Empowerment Act that sought to increase Black ownership in corporations. It was subject to various critiques. There were transfers to Black owners, but those were mostly politically connected Blacks. There was a broader initiative in 2003 in an act called the Broad-Based Black Economic Empowerment. And that is broad-based because it sought to increase racial diversity and also in a cross-sectional way. There were specific points in the scorecard system awarded for also Black women directors, for instance. So it sought to increase Black ownership, Black participation in boards, procurement from Black firms, training of Black employees through a balanced scorecard that would give advantages in procurement and licenses from the government. It ended up increasing significantly racial diversity in South Africa, though people would say, well, this is highly disappointing, given it's a majority Black country. It depends on what you compare it to. Compared to Brazil, where until recently there were 0% directors in Brazilian boards, it looks like some progress was made. South Africa was not alone. It was actually preceded by Malaysia, that since independence had initiatives of a board of corporate ownership by the local Malay population. And in that, I thank Umakanth. He's going to be my commentator today, but he was my commentator earlier. And I thank him for this point, because before he told me that, what I had read in the comparative corporate governance literature is that Malaysia, well, it's a country that has state-owned enterprises, but beyond that is a country that just ranks at the near top of the World Bank's doing business ranking. So those other issues are not generally captured in the conventional debate. I also mapped constitutions of Global South jurisdictions and Global North jurisdictions. In contrast to private law and corporate law, there has been a booming literature on constitutional law in the Global South, and recognition that those countries have different constitutions that are more recent, longer, more progressive than the types of constitutions that we have in the Global North. Some scholars described it as a form of transformative constitutionalism. And one theme for me here was to see whether there were provisions in those constitutions that related to corporate law themes. I mentioned co-determination, some mentions of co-determination, though little in practice. Global South jurisdictions are really into the idea of cooperatives. So some constitutions even have several mentions of the cooperative type of organization compared to only 2 of the top largest Global North jurisdictions. And they're also more likely to have provisions on workers' profit sharing. It is also the case that bankruptcy statutes and corporation statutes are often subject to judicial review in Global South jurisdictions as potentially violating some of the more socially oriented provisions in those countries' constitutions. And it's really interesting that Brazil also has had a famous constitutional court decision, which is in some ways opposite to Citizens United, because Brazil had a statute authorizing legal persons to make campaign contributions, but the court actually found that that corporate political spending was unconstitutional as posing a threat to social inequalities. I would also now that I've presented the different varieties of heterodox stakeholderism, pause and give some working hypotheses or interpretations of this phenomenon. So why is it that we see those forms of heterodox stakeholderism in the Global South? And I would suggest that one way to think about it would be as a challenge or perhaps even a corollary of the standard mode of law and economics thinking, which I have termed the modularity approach to law and economics, which is what most of us do implicitly, which is to think that different areas of law can contribute to social welfare in one particular way. For corporate law, that would be the reduction of agency costs, and then we would say that concerns about environmental externalities should be addressed by regulation, concerns about inequality should be addressed by the tax and transfer system, and so on and so forth. Well, and I think this is a growing debate right now in this country and in the global North more generally, but what if other areas of law are not doing what they're supposed to? What if, and this is a common theme these days, what if environmental law is not tackling the climate crisis? What should finance do? We heard a lot about that yesterday. So guess what? The idea that other areas of law are not doing their job, and then we have a very unsatisfactory situation that requires immediate action, crisis, that has long been the case in the Global South, and perhaps that helps explain this less modular approach in various instances to corporate law institutions. This view of heterodox stakeholderism also has some implications about the debate regarding the evolution of corporate governance. So my dear mentor, Henry Hansman, was here yesterday. He was famous for the thesis that we would see the end of history of corporate law and convergence toward the shareholder value model. Some people would say the US model. And certainly I think most of the literature thought that the Global South would converge towards the model available in the global north. But here I'm suggesting that we might be seeing some form of reverse convergence in that corporate law debates, conferences for sure, and laws also to some extent in the global north have become more open to broader public policy objectives and less modular. I would also want to offer another factor in heterodox stakeholderism in the global south, and that has to do with a theme that is a common theme in other areas of law, but has not been a significant theme for corporate law. And that this is the idea of global north, global south distribution. So scholars of IP and patent law are very much used to the idea that, for instance, the level of patent protection that is optimal for the global north is not optimal for the global south, because the global south is more likely to pay for patents than to produce patents, and so a strong patent regime distributes resources away from the global south to the global north. That type of thinking is generally absent from corporate law, but I would like to just suggest here that it might be one clue toward understanding some of those varieties of heterodox stakeholderism, and I would like to focus on one, which is the erosion of limited liability. I think it's perhaps no surprise that those have been, despite what is almost, I think, a law and economics consensus, despite Hansman and Crackman and their view that you shouldn't have limited liability for torts or involuntary creditors. And yet, global south jurisdictions have moved first in the erosion of limited liability, and I suggest that that dimension of north-south distribution might have played a role, given that limited liability might work to the detriment of global south victims, to the benefit of companies and shareholders that are located in the global north to a significant extent. I believe this discussion has some payoffs about how we think about comparative corporate governance. It will help incorporating the global south more broadly into the debate, would help challenge the World Series syndrome of comparative corporate governance, which is also viewed in other areas of comparative law, by which people might generalize about global developments based on the experiences of just a select group of jurisdictions in the global north. And I also suggest that it might also overcome what, my slides are so bad. Sorry. Mark, I mean, you warned me. You were onto something. I'm so sorry about that. Okay. I'm so embarrassed now, you know. Okay, no, never mind. To the odd drug, you know, I'm still in the global south. So maybe you have, okay. There is also actually a cartoon that I show some, that I found in a very famous Argentinian, cartoon style called Mafalda. And she says, well, you know, we are upside down. Look at the map. We are so upside down. That's why our ideas fall. Anyhow, I think the literature has suffered from an odd duck syndrome, which is that because generally studies of global south jurisdictions are case studies done in isolation, and the only benchmark is the global north. It's very common to see this perception that those jurisdictions are exceptional, while in many cases we have more global south commonality. So this is the case, for instance, with respect to the regime of enterprise liability in India, which is described as the literature as exceptional. But guess what? Brazil has a similar, perhaps even stronger regime in that particular regard. So this paper and project, it's also part of a broader project, offers new perspectives on the evolution of corporate law. It shows how social and economic challenges might put pressure on corporate law to accomplish or try to tackle, or even appear rhetorically to tackle broader political and social concerns. I would say there is a surprising trend of reverse convergence in comparative corporate governance. And I suggest that there should be greater appreciation of the distributional implications of corporate law rules as an interesting agenda. And with that, I thank you very much for the opportunity.
Indeed, very delighted to be here at GCGC, and also even more delighted to comment on Mariana's paper. If I were to summarize Mariana's paper in one word, my slide one starts here. It says, this clearly symbolizes what the work that she's done, because it truly has a global impact, because corporate governance has wide implications given globalization, and her work does justice to that kind of approach. So my comments here are going to be twofold. Just to give my take on the contributions of Mariana's paper to this conference, and then secondly, to raise some questions for consideration as we move forward. So as I've already mentioned, this work is really pioneering, because a lot of work done on corporate governance until now has pretty much ignored the Global South. So Mariana's work actually mainstreams the Global South in this conversation, and kind of makes that as a centerpiece of the conversation in that sense. And this is actually extremely important, because as The Economist very recently has suggested, the Global South accounts for 40% of the world's GDP, and more importantly, 85% of the global population. So any conversation that we need to have in corporate governance needs to encompass this broader section of society. And most importantly, a lot of what Mariana has covered includes jurisdictions like Malaysia, for example, that haven't really received a lot of attention in the past. So that's a very important aspect. And she also takes a very novel approach. She brings in the political aspects, the various imperatives that led to stakeholderism in these jurisdictions, which include things like the inequality in these jurisdictions and the lack of state capacity, because these two issues are pretty important in the Global South jurisdictions. And as Mariana has also said, quite often in the Global South, stakeholderism is also a way to address the perceptions that people have about the role of corporations in society. Because quite often in these jurisdictions, corporations do not necessarily have a positive role or a positive perception in society. So quite often, and this has been verified in many jurisdictions, including in India, where the role of the government in including stakeholder provisions has been to address the negative perceptions that corporations have actually had in society. And then finally, I think my main takeaway from Mariana's paper is this concept of reverse convergence that she comes up with, which I'm going to talk about a little in greater detail. So where does Mariana's paper fall within the whole comparative corporate governance scholarship? And I think I've tried to put it in three paradigms. And a lot of people in this room have been involved in developing a lot of these areas of scholarship in many ways. So we've had the North-North comparative scholarship for a long period of time. We've had discussions and papers on US, UK, EU convergence and divergence. And we've also had jurisdictions like Japan involved in the process since the 1980s and the 1990s. And then, as Mariana said, there have been a lot of North-South comparisons. And the North-South comparisons have largely tended to involve single-country comparisons. Why did Brazil develop its corporate governance the way it did? Why did South Africa develop it the way it did? Why did India develop? And those are conversations between the developing or global South countries, and then cross-referencing that either to the UK or the US. And developments in the UK and the US, such as the Sarbanes-Oxley Act, the Corporate Governance Code, the Cadbury Corporate Governance Code in the UK, have been used as cross-references to these developments in the Global South. But what Mariana does is the third, and she does, which is to bring the South-South conversation into the picture, not just cross-referencing with the North, but also examining the comparisons between the various jurisdictions in the Global South. And this is, I think, a very important contribution the paper makes. And as I would suggest later, I think this is a paper which could actually lead to a lot more work in this area in increasing the South-South comparisons over a period of time. Now, Mariana has also addressed a wide range of issues, and I'll come back to that. And I think the important part of the scholarship is also the range of countries that it covers. So it addresses a number of issues on the left-hand side, and it also covers a number of different jurisdictions on the right-hand side. And one of the things I must say in terms of my own experience, I do a lot of research relating to India. That's my kind of my day job. And Mariana has a number of pages written about India. I tried my best, but I couldn't find a single sentence that was wrong. So she's done a very good job in kind of, I'm assuming that goes for other jurisdictions she studied as well, because if it worked for India, I'm assuming it works for other jurisdictions as well. So I think that's really very creditable for Mariana to have undertaken this extensive analysis. But I'm assuming that I haven't been invited here only to praise Mariana's paper. So I must also raise a few issues for consideration. And I raise 5 issues for consideration, either in this particular paper or for further work that Mariana is best capable of carrying out, or others in this room may be considering as well. And what are these issues? The first question I had for Mariana is there such a thing as a global south? And if so, what is it? Does it have a distinct identity? Or is it something which is nebulous, which is sought to be put together in this paper? And I think it's very clear from the paper itself and otherwise that there's a lot of heterogeneity in the approaches that these different jurisdictions adopt. And there is no coherent strategy that each of these countries adopts. And Mariana has set up a lot of different strategies. It's very evident that each country follows a different approach. One focuses on CSR, another may focus on giving workers rights, others may focus on affirmative actions. So the context matters quite a lot, and which strategy depends upon the context for each individual jurisdiction concerned. And then, therefore, a common approach may be difficult to follow. And so, therefore, the approach that Mariana has followed is necessarily illustrative. So it is not necessarily that each strategy would work for another different country. It depends upon the individual jurisdictions concerned. And one of the questions I had for Mariana is, for example, some of the strategies do not even involve corporate law. So some of it could involve constitutional law. So that's, one of your studies involves looking at the constitutions of different countries. So is it a design of corporate law? Or is it a design of different areas of the legal system that impact on corporations? Is that what the study is all about? I think that would also depend upon the individual jurisdiction involved. So first question is there like a global south? What do we really mean? And is there a core identity and a core consistent, coherent strategy that's possible for governance of these jurisdictions? The second question is, when we think about stakeholderism and heterodoxy, is that a unitary phenomenon? Or is that phenomenon much more dynamic in nature? And I think one of the things that is assumed in the paper is that all these countries have been stakeholder-oriented from the beginning. They have been pushing towards stakeholderism, but the reality may be different because, as has been suggested in previous scholarship, there has been oscillation between shareholder primacy and stakeholderism in different jurisdictions. And some of the papers have already looked at that in the context of China and India, which are mentioned here, where it's difficult to say that there's one particular strategy. At different points of time, depending upon the imperatives, they have been oscillated from one side to the other. And there's also theoretical discussion about this in the 2022 paper by Gilson and Milhop, where we need to think about stakeholderism along a continuum, and it's not just a unitary phenomenon. I won't get into the details of this because this has been discussed very clearly in this paper. And the other issue, which is also important, which Mariana's paper can potentially delve a lot into, is there any correlation between ownership structures and the place on the shareholder-stakeholder continuum that each country is? Will increase in concentration result in stakeholderism? Will the nature of controlling shareholder result in more stakeholderism or less? Does government ownership result in one way or the other? So these could be issues as well, which can be considered in greater detail in this analysis, so which would make this quite interesting as well. So the second point is largely stakeholderism, not as a unitary phenomenon, but as something more along a continuum. which I know is going to be discussed in the next paper as well, from what I've seen from the draft. So I won't steal their thunder any longer. So I'll stop at that. The third, I think, is the most important point, which Mariana makes an assertion that all these phenomena result in what she refers to as reverse convergence. So my question is there sufficient evidence of reverse convergence? And the reason why I ask these questions is, firstly, the conventional understanding of convergence, as Hansman and Crackman and others have established, is there is an ideal endpoint. And the convergence is towards that ideal endpoint. And so here, are we saying that stakeholderism is the ideal endpoint and the convergence has to be towards that, number one? The second point, the question that I have is this reverse convergence by default or by design? Because when we looked at convergence in the conventional sense, a lot of the convergence happened by design. So countries looked at the US, countries looked at the UK, and tried to establish corporate governance systems based on that through legal transplants, for example. And there's a lot of debates about efficiency, inefficiency of legal transplant. So there's been an ideal endpoint, there's been a cross-reference point, and all jurisdictions have been looking to that. Now, do we see that in the reverse convergence? I'm not sure if we have evidence of that, because I'm not sure if countries like, say, the US move towards ESG is driven by what's happening in India or in Brazil or South Africa. I'm not suggesting that it needs to happen that way, but is it an accident or is it a more deliberate phenomenon is something that we need to think about. But at the same time, when we think about stakeholderism, there is continuing understanding or continuing phenomenon of conventional convergence. So for example, the ESG discussion in the Global South is not coming from within. The ESG discussion is being driven by what's happening elsewhere in the Global North. And Jennifer has a paper on this. The role of supranational convergence is also important. So where is the ESG disclosure coming from? It's not so much from within these Global South jurisdictions. It's still being driven by TCFD, now IFRS, and so on. So is that kind of, does it have an impact? So the question, therefore, is, do we have sufficient evidence of reverse convergence? But I think that's something to consider. But the concept of reverse convergence is a very interesting phenomenon. The only question I have is, how do we kind of build upon that, either in this paper or a paper in the future? The fourth point is, what are the different strategies? And now, in your paper, you have 6 strategies that you have considered. But I would suggest that there are further strategies that could also be considered. And one of the important discussions that people are having in the Global South is, what are the duties of directors of companies? Is it only to consider the interests of the shareholders, or is it to consider the interests of other stakeholders as well? And for the legally minded people in the audience, in most non-US jurisdictions, at least in the Commonwealth, the duties are owed only to the company. Duties are not owed to the shareholders. But even though duties are owed to the company, the duties include the duty to consider the interests of other stakeholders. And I've given India as an example here, and the last point is fairly interesting. And this has generated a lot of debate, where directors of Indian companies under the 2013 Act have to consider the interests of various stakeholders, and shareholders are only one among them, right? So other stakeholders also have to be considered in that. So an analysis of maybe the different jurisdictions in the Global South thinking about directors' duties would also be useful. And there are many others as well. In interest of time, I won't go through all of them. For example, what are the provisions in corporate charters? Liu and Lin has a paper in 2019 in China about how the corporate charters of different companies have considered the interests of stakeholders, board diversity requirements. For example, some jurisdictions have a legal requirement that there have to be women directors on boards. So how does that add to the stakeholderism debate is an interesting example. And then there are many other aspects as well, including the transition now from CSR to ESG. But I think the last point is the most important one, which is, yes, all these jurisdictions have the concept of stakeholderism. So what? What if boards don't commit themselves to stakeholderism? How do these jurisdictions enforce these provisions? Now here, I think you mentioned it yourself, Mariana, in the beginning, that enforcement is a big issue in these jurisdictions. And I think that is the big question mark. So is stakeholderism in the Global South a mere case of virtue signaling? Or is it based on legally enforceable rights, either of shareholders or other stakeholders? How do you enforce and implement stakeholderism? I think that's kind of the issue that we do have in these jurisdictions. And the last point, and I'll stop with that, is the elephant in the room, or as Dan would like to call it, the panda in the room. Yeah. So your paper deliberately and consciously excludes China. So I'm not quarreling with the coverage of the paper, because you very clearly said that you're not interested in covering China. But my question is, how does it look when we throw China into the mix? And we can't ignore China, because China is the largest economy in the Global South. So how does China feature in the context of corporate governance? I know one of the aspects you've considered is the fact that it's not a democracy. It has a different political dispensation. But does that matter in the way we look at for corporate governance? I think that's something to think about. And there are a lot of single country analysis of Chinese companies and stakeholderism. But I'd be curious to see how China fares in the whole mix of Global South jurisdictions that you have considered. So that's something to think about as well. But finally, I think overall, it's a great paper. And as I've said, I really mean that it's a pioneering paper as far as I can see it. And there's a lot of scope for so much more scholarship coming from this as a framework paper. So overall, I'm very happy to have read and commented on this paper. Thank you.
Thank you, Umakanth. That was very encouraging. I must say that some background about this project. I owe this article in particular to people in the room. So first question about the Global South, and Georg reminded me of that. He's like, Mariana, this agenda of yours dates back to the Oxford Handbook that Jeff and I edited, and we invited you to write a chapter on corporate governance in emerging markets back in the day. And of course, I mean, it's not that I only wrote about Brazil, but I wrote primarily about Brazil, though some of my papers had other countries, and I was a very young scholar, so I said yes, and I did something, and I did something in the most conventional way. So Umakanth mentioned ownership structures. Do they matter? Do they relate to this? I would say yes and yes. But that's how I approached it. Oh, you know, countries in the Global South, they have a lot of state ownership, they have a lot of family firms, they have a lot of business groups, and that's the way and that probably relates to poor law, and those are adaptations to poor law. So that's part of what I did. But I did something else, which is like, oh, but there are other very odd things going on. So I mentioned, for instance, the availability, the erosion of lock-in Brazilian law, the fact that minority shareholders of closed corporation can simply withdraw and capital from the firm, and I began exploring this idea that those heterodoxies, those differences, were an adaptation to a different institutional environment. And then by now, almost 2 years ago, Dorothy, she's not here today, but she was here yesterday. She invited me to also say, well, I'm gonna having this Burley symposium on stakeholderism. Why don't you write something about developing countries? And at the time, I mean, I was under intense pressure to publish, being a faculty member in a Global South institution whose government has very heterodox patterns of productivity. So I said yes. My plan at the time was to combine my work on the erosion of limited liability and lock-in, which was ready, with China. So I had the paper. It's like, fine, I'll do that for Dorothy. You know, Brazil and China, that's easy. But then I was like, oh, Mariana, it's so not exciting. That's not what I like doing, writing, papers, things that I know already. So I was like, well, why don't I start looking at South Africa? Why don't I look more at India? Oh, I'll look at here, Indonesia and Malaysia. And now I'm into this rabbit hole, and I must say, that's not over. Just last week I sent
a manuscript for a book volume with Kevin Davis on legal heterodoxy in the Global South, which also covers other areas of private law. And I think there's a lot more to say. Just let me say a few things about Global South. Look, I started with emerging markets. Actually, it wasn't even me. It was Jeff and Georg that thought that it was a plausible category. Now, later in my legal heterodoxy project with Kevin Davis, was like, no, not emerging markets. That's even confusing because sometimes they're emerging, sometimes they're descending. So, and even markets, a lot of what's going on is super like social. So now I really hate emerging markets. So I'm not talking about emerging markets anymore. Then I was going with the developing countries. That's how I started the project. And I think there's something to be said about how different levels of development and different histories will affect institutions more generally. So I do think there's commonality there. But really in the last few years, Global South took off. And actually people who I think are more likely to take an interest in this type of project, they're really into Global South. So that's why I'm calling it Global South. I mean, I take your point, of course, that Global South there's a lot of heterogeneity in the Global South. There's a lot of heterogeneity in the Global North. By the way, what about in Brazil? Like some people say, well, sometimes I have scholars who have heterodox ideas and they tell me, oh, Mariana, maybe you should look into issues that are really of interest in like some very remote states in Brazil. But I cannot do that. That's a completely different agenda. Brazil is so diverse internally. I mean, that's the case everywhere. I think the point is there's something to be gained by having this broader category. And even civil law, common law. I mean, there's how many papers on that? Some people think it's completely useful. I don't think so. I don't think it's completely useless. I think you get something by it. And I think this cleavage, I think it's a very plausible competitor and an interesting angle. And certainly in this line of research, I have found that there are things that are common. And I think that things that are important to those countries. I started this project just talking about contract law and about how there's like welfare, distribution, social justice talk in Brazilian corporate law. And in Brazil, people attribute that to a certain school of thought in Rio de Janeiro. You know, that's our origin story. We have that because those people came up with those ideas. But look, South Africa also has a similar tradition. Argentina also has a similar tradition. Colombia has a similar tradition. So maybe, could it be something about the characteristics of those countries that make those approaches more attractive? So this is precisely what I'm trying to address. I know about director's duties. I didn't get into director's duties because First, I think there's a huge US versus rest of the world cleavage on director's duties, and no evidence whatsoever that it makes any difference. And I think that might be a fair point for some of the things I have here. That's the effectiveness point. Umakanth, by the way, I don't think that's a critique of my paper. I think the effectiveness thing is an open question for the stakeholder debate everywhere, and I think the discussions in this conference confirm that. Though for some of the issues here, they're different. I think certainly limited liability in Brazil is harder, perhaps more consequential, and maybe in other jurisdictions as well. Finally, I would just make a point about reverse convergence, and of course, completely agree that the rise of ESG is not global north jurisdictions trying to emulate the global south. I mean, they don't even know what's going on in the global south, much less that. By the way, the global south is not generally perceived as appealing to many people. So clearly that's not the story. But something that I want to just to note in that remark, and that concerns the role of international organizations, and I have written on the rise of international corporate law, and I think that's a 4. ESG comes from that, and that it's influential in the global south, influential in the global north. And the point I'm making now in the new edition of the chapter of the handbook, which is now called, I think, what is it called? But it has to do with corporate law and in the global south. Yes, for sure. Yeah, that's the 2024. I was like, I'm doing it, but it's like global south. But I'm suggesting that is that it's not that the global south is the model, but I think that the global south is in part an inspiration for those moves. So back in the day, the global south wanted to had proposals at the UN level to impose liability in the global north, to preserve a policy space in the global south. And actually, a lot of what we see now, both in the ESG level and certainly also in the EU sustainability, 3D, directive level, is using corporate law to regulate the global south. The very EU directive says, well, we are doing this. Also, it's good for developing countries. So one way to think about those developments is not that they're driven by imitation of the global south, but I do think they are aimed at the global south. And in that way, the global south is having an indirect impact as well in other debates, though that's not particularly this paper.
Thank you so much. We have a fairly long list of questions, so is it okay if we take them 3 at a time? Let's start then with Roy, Asaf, and Kobe. Roy.
Thanks, Mariana. So going back exactly to the point about reverse convergence, so I guess the thesis is that global north countries are just now adopting legal institutions that global south countries adopted earlier. But I was wondering about market institutions. So think about your examples. Already in the 1990s, large US firms converged around a market norm of donating 1% of income pre-tax. So there's already a market norm, there's already a market threshold, and then India is passing this law in the 2000s, but that's a legal institution. The market institution was there, I guess, before. Or think about the example of South Africa and workers being able to hold managers accountable. Already in the 1990s, if you're a worker in a high-tech firm in the US, you get stock. And with this stock, you get inspection rights. And if I recall correctly, Jill has a paper showing that now managers trying to waive these inspection rights precisely because they are being used to hold managers accountable. So how do we treat in this reverse convergence hypothesis the difference between market institutions and legal institutions?
Thanks so much, Mariana. This is simply terrific. It's a fountain of ideas that send me in so many different directions. I just want to say 2 things. First of all, did you find any exception? The word stakeholderism is in the title of the article. Did you find any jurisdiction in the Global South where there is at least rhetorically a move towards shareholder primacy, or some rhetoric that's similar to what we're seeing in the Global North regarding shareholder primacy as opposed to stakeholderism? And if there was no exception, that's extremely interesting. And second thing, in one of your slides, you said limited liability of parent companies often benefits Global North companies and investors, but harms Global South jurisdictions, and that's why limited liability is being chipped away. Actually, there is an interesting story here, sort of a convergence story. Same sort of thing happened in the United States in the 1980s with so-called constituency statutes, where states where the productive companies were located, states like, I don't know, Nebraska, Illinois, passed statutes that make takeovers harder. But Delaware, which did not actually have those production companies, but just had like the incorporations, did not have this constituency statute. So in a sense, there is a second order convergence here, something that maybe vindicates Henry and Rainier's work in a new and surprising way. So again, thanks a lot and really interesting.
Thank you. Kobe.
Hi. Again, this is really interesting. My question is actually about the connection between your work to the legal origin work that you mentioned. And I think it could be interesting to look at jurisdictions who start from the same family, so common law jurisdictions versus civil law in the Global South, and then try to see to what extent a specific jurisdiction deviated from what they had as a standard, and what were the reasons behind this deviation and the dynamics. Then you get a nice benchmark of companies that started in the same place but then moved there. The other question is about, and it was mentioned earlier, law in books and law in action, and people mentioned, so the commentator mentioned the enforcement point, but I think it's interesting. So if I think about limited liability concept in Israel, it's complicated because there's the corporation law, but there are many other pieces of law that are relevant to that, and courts provide their own interpretation. So this is just a question of how do we do this type of research in a way where there are so moving pieces going on in each jurisdiction.
Mariana,
Yeah,
would you like to
so thank you. So first point about market institutions in Global North having preceded some of those. Well, that's possible. I don't want to rule that out. I don't think it applies to all such cases. I don't think it applies to limited liability. I think the committees, CSR committees, ESG committees were different. But I'm actually not hostile at all to the idea that, and that relates to the other point about constituency statutes, that Global North jurisdictions also face, if you don't like it, you might call it populist pressures and do some things that are similar. And I'm not really so worried about, I say here, pioneering, in the sense that, what I want to stress is that I think it's a style that's quite prevalent in the Global South and hasn't been quite documented, but it doesn't bother me if the Global North did something earlier in a different way. So right now, I'm looking at how Brazilian law has had joint and several liability in corporate groups. I thought since the 1942. Now I thought it was 1936. Now it's like, no, it's actually case law before that. And I had a student actually at Stanford when participating in Curtis's course. He was, but that's not the Global North. Well, that's not the Global South, because New York has had and still has. By the way, it's increasing, shareholder liability for to workers. I think this is really interesting how different jurisdictions have incorporated those broader objectives. I just think that the traction that you see in the Global South maybe is a bit stronger in some respects, but not, of course, not in others. And I mentioned co-determination. Now, it's.
Is there exception?
Oh yeah, yes, of course there's exceptions, because those things are not, heterodoxy is not universally accepted. I mean, those are real countries, those things are contested. And I see here Emiliano. And Argentina now has a huge anti-heterodoxy backlash. Milei gets into power, he has a provisional measure, and one of the things he wants to change immediately is the civil code, including contract law rules. How do I read that? I read that as backlash against contract law heterodoxy. So there is backlash from time to time, for sure. So I think that would be my reading of Argentina. By the way, Argentina was not quite stakeholderist this way, but it's done it in other ways. So there is a backlash. Those things are contested. Nevertheless, they are quite strong. Brazil almost passed a statute curbing veil piercing, and yet Bolsonaro vetoed it in its entirety, which for me goes to show that there's something about those institutional environments that perhaps demand such solutions. If you don't have control of related party transactions, if you don't have a criminal law enforcement against shuffling around assets, maybe veil piercing serves as a substitute, and that's how I read, those developments. And the last comment, I'm sorry, I got lost.
Never mind. Maybe you want to.
No, please do. Oh, common law, civil law. Common law, civil law. Yeah. So common law, civil law. That's a great point, and I'm trying to explore that in other projects. So just give me just one example, because I really like that point. Trying to run both theories and see which one gets you farthest. In terms of like social penetration in corporate law rules, I want something that's very easy to look at. Or not quite corporate, well, corporately related. I thought, I'm gonna look at priorities of workers vis-a-vis secured creditors in bankruptcy, just because that's kind of a rule, and I think that's kind of straightforward. So this is what I'm doing right now, and I think this is really interesting because this first emerged in France, and the priority of workers vis-a-vis secured creditors. But workers were not yet first, and then it's in the Mexican Constitution of what, 1917, 1919? Now, I don't recall exactly. Workers' priority in bankruptcy in the Constitution, workers come first. After that, workers first really spreads around the world. And it's actually in the constitutions of various Global South jurisdictions, no Global South jurisdiction. So I think this is interesting because the way you would see, well, they are all French, But in a way, work is very top spot. It's something that came from the Global South, and I would say has spread through the Global South. Also things in terms of limited liability vis-a-vis workers. There was a lot of South transplant in the early 20th century. Okay, I'm very excited. Oh, sorry.
That's great. We have 8 more questions and 3 minutes. So let's take 4, and please be mindful of the time. Drav, Jen, Georg, and Jeff, in that order.
Thanks. Very interesting paper. Isn't a common, the discussant asked about a common theme. Isn't one common theme the government expropriating unpopular constituencies? Like the Malaysian example, right? You're just expropriating the Chinese origin people. And in the Indian case, you know, it's a socialist country. Private enterprise is deeply unpopular with the government. So they're just, the legislative history shows the government wanted to force the private enterprise to give them a slush fund to help fund, you know, help politicians appeal to the electorate. So one explanation for the evolution of stakeholderism could just be, you know, elected officials basically punishing politically unpopular constituencies or firms.
Thank you. Again.
Right, so thank you so much, Mariana. So it is a great paper, and I really learned a lot. I actually once wrote that no countries in the world have ever denied limited liability in Japanese, but I had to change that. But anyway, so to me, it seemed that like it's very context specific. So like in India, after Bhopal disaster, you denied limited liability. In South Africa, after apartheid, you changed kind of to have more like diversity in the boardroom. So if this is really like context specific, so your second part of your message, which is the reverse convergence, to me that didn't fit well, because if it's context specific, maybe it's more like no convergence at all. Every jurisdiction has its own agenda doing different things, and it also applies to global norms. So maybe you can like elaborate a bit more on that. Thank you.
Yes, thank you, Mariana. Great project. It's really nice that 2 people from the global north gave you the incentive to reflect upon this. But I wanted to ask you, so in a way, what you're doing at the moment is sort of outlining this thing and saying that the world is colorful and different. And I was wondering whether you have anything to say on the more normative side, on whether that heterodox stakeholderism actually works, and is there anything to be learned from one side over the other? Are there sort of efficiency improvements even? Or is one model superior over the other? Big question, of course. And relatedly, whether there is any friction when we cross the north-south divide, right? In a way that, for example, I can imagine that investors from global north countries don't like the idea of being subject to a possible piercing the veil when they invest in Brazil, right? So that there might be pushback also from the global north against that line of travel that you're pointing out. Thank
Jeff, but just a minute, Mariana. We are now soon over time. Do you want to collect all the questions? We still have Mark, Asaf, John, and Tobias left, and then perhaps just a very, very short response in the end. Okay, Jeff, thank you.
Yeah. So this is kind of a follow-on from Georg's point. What would be the implications of the political settlements that you've described on ownership? So, you know, to channel Mark Rowe, maybe I think, would this lead to concentrated ownership in the sense of the necessity for owners to be able to push back against government efforts to actually enforce the rules that are on the books? Do you see the implications for foreign ownership, for the ownership by the BlackRocks of this world, with the implications for foreign direct investment? what does this do for, you know, work you've done yourself on the nouveau market in Brazil? Has the flow through of the political of the rules that flow from the political settlements you've described impeded or advanced some of the objectives that you push for in that part of your scholarship? So in a way, that's kind of the follow-on. Yeah, there is sort of the descriptively the differences that you've described, but you know, how would we begin to think about them as you know, output on other things we might think are desirable?